appeal, Queen on the application of Paul Black, and the Secretary of State for Justice.
Yes, Mr. Havers.
Please, Your Ladyship and my Lords, I represent the appellant on this appeal, together with my own friend Ms. Shaheen Rahman. The respondent is represented by my own friends Mr. Eady and Mr. Pievsky. My Lady, the underlying issue in this appeal, as you will all have appreciated already, is whether the Crown is bound by Chapter 1 of Part 1 of the Health Act 2006. Mr. Justice Singh at first instance held that it was. The Court of Appeal held that it was not. The issue arises in this way, if I can summarise very briefly. The appellant is a prisoner currently detained at HMP Wymot. He is a non-smoker and he suffers from a range of health problems which are exacerbated by exposure to tobacco smoke. He complains about his exposure to such second-hand smoke in the common parts of the prison, and that the ban on smoking introduced by the Act is not being enforced in those common parts. He argues that he and other prisoners should have confidential and anonymous access to the NHS smoke-free compliance line to report non-compliance to the local authority, but the respondent refused that request on the basis that it would serve no purpose because the Act does not bind the Crown, since HMP Wymot is a state prison. And that is the decision which he has sought to quash. My Lady and my Lords, I propose to say no more than that by way of introduction. And before I turn to the statute itself, can I show the Court some of the more important relevant materials that set out the background to the statute? Can I begin by inviting you to pick up Volume 3 of the Authorities Bundle and to go to tab 30, page 961. The MS number is 1292.
So what is this?
This is the appendix to the decision of the Court of Appeal in the case of the Queen on the application of N against the Secretary of State for Health. If the Court would go back to page MS page 1268, the internal numbering page 937, you will see from paragraph 22 of the judgment of the Court of Appeal that Appendix A sets out the Divisional Court's summary of the evidential background to the Act. And paragraphs 16 and 17 on page 961, MS 1292, provide a convenient starting point for the background to the 2006 Act. And as you will see from paragraph 16, the 1998 White Paper, Smoking Kills, estimated that smoking in the UK caused each year 46,500 deaths from cancer and 40,300 deaths from all circulatory diseases. Those who smoke regularly and who then die of smoking-related diseases lose, on average, 16 years from their life expectancy when compared with non-smokers. In reports of 1998 and 2004, the Scientific Committee on Tobacco and Health concluded that exposure to second-hand smoking was a cause of a range of serious medical conditions and recommended restrictions on smoking in public places and workplaces so as to protect non-smokers from second-hand smoking. The overall increased risk of lung cancer for non-smokers exposed to SHS was put at 24%. In December 2005, the House of Commons Health Committee reported that SHS caused at least 12,000 deaths a year in the United Kingdom, and of those deaths, 500 were due to the presence of smoke in the workplace. Can I then take you to volume 2 of the appendix, volume 2 of the core volumes, that's to say to the appendix, and ask you to go, please, to page 290. The MS number is 415.
As a matter of interest in the N case, Rampton Hospital is presumably Crown property.
Yes, must have been.
But the whole the point was never taken that none of this applied.
No.
Is it not?
Oh, I'm reminded that Crown immunity doesn't apply to the NHS, but that was a prison, of course.
Well, it was a secure hospital.
Secure hospital,
Yeah.
secure hospital.
Yeah.
But it was managed by the NHS Trust.
It was managed by the NHS Trust. That probably explains it. Yes, I'm grateful. So if one goes to
Hospital, it's not a prison.
page 290 in the appendix, MS 415, you will see that this is the forward to, if one goes back to 288, Department of Health report, Smoke Free England 1 year on. And the forward is written by the then Chief Medical Officer, Sir Liam Donaldson. And you will see that he writes, "A year ago today in England, we took one of the most important steps forward in public health for many years. The importance of this law cannot be underestimated. It has resulted in a significant reduction in exposure to second-hand smoke with all its damaging effects. We expect that lives will have been saved." I first called for public places and workplaces to be made smoke-free in my 2002 annual report. The following year, my 2003 annual report set out the economic case for smoke-free legislation and recommended that smoke-free workplaces and smoke-free enclosed public places should be created as a priority through legislation. Therefore, delighted when the House of Commons voted in favour of legislation to make all enclosed public places and workplaces smoke-free.
Mr. Hayes, is there a contrary view on this? It's not like climate change, is it?
Well, I don't think there is any longer, no.
Yeah.
The
It might be thought that it's fairly... I mean, it's very interesting, the statistics, and horrific, some of them.
yes.
Well, I'm not sure how much one needs to emphasise the dangers of smoking.
Well, Lord, it's not so much the dangers of smoking, but the dangers
Second-hand smoking.
of passive smoking, yes, second-hand smoking.
One's very aware of it, so
Yes.
you won't only have to sit next to someone at a next-door table who's smoking outside.
Absolutely.
Presumably, Sir Liam means the importance of this law cannot be overestimated rather than cannot be underestimated.
Should not be underestimated.
Should not be underestimated or cannot be overestimated.
If I can just read the next paragraph, because it'll save me coming back to it later. 1 year on, and the smoke-free law has been accepted by the general public and businesses alike with almost universal compliance from day one. And then, at the risk of unnecessary emphasis, if your lordships and my lady would look across to page 291, you will see from the second paragraph a little more detail on what medical and scientific evidence has shown in relation to exposure to second-hand smoke. And it provides more detail in identifying the serious medical conditions which are put at risk, such as lung cancer, heart disease, asthma attacks, childhood respiratory disease, sudden infant death syndrome, and reduced lung function. And one sees from the last sentence, the only way to provide effective protection is to prevent people breathing in second-hand smoke in the first place. Lords and my lady, this takes me then to the Department of Health white paper, which preceded the Act. In the appendix, if you would go on, please, to page 406, MS page 531. You will see at 407.532 an extract from the white paper. Paragraph 76, nevertheless, this is an area where people cannot readily secure change for themselves. In our 1998 white paper, Smoking Kills, we were clear that fast and substantial progress was needed. We decided that the case for legal action to restrict smoking was not at that time sufficiently strong. However, change has been slow and public demand for action has increased. It's one of the few instances in this white paper where we believe the right response is government action in the form of legislation. We therefore intend to shift the balance significantly in favour of smoke-free environments subject to parliamentary timetables, we propose to regulate with legislation where necessary in order to ensure that all enclosed public places and workplaces other than licensed premises will be smoke-free. And then they set out how licensed premises are to be treated.
So now that's a white paper, Mr. Havers. Date?
Sorry,
It's a white paper. Date? Just
2004.
Thank you very much. Just before the 2006 Act. Okay.
And then paragraph 77, we intend to introduce smoke-free places through a staged approach. By the end of 2006, all government departments and the NHS will be smoke-free. By the end of 2007, all enclosed public places and workplaces other than licensed premises and those specifically exempted will, subject to legislation, be smoke-free. By the end of 2008, arrangements for licensed premises will be in place. We will use the intervening period to consult widely in the process of drawing up the detailed legislation, including on the special arrangements needed for regulating smoking in certain establishments, such as hospices, prisons, and long-stay residential care. In implementing this policy, there are also a range of practical issues that will need to be addressed. We will need to consult, for example, with schools and other institutions on how best to give practical effect to this policy, as well as how best to enforce the policy and what penalties will be appropriate for people who do not follow the law. So that, in summary, was the position leading up to the 2006 Act. Domestically, so far as the EU position was concerned, can I ask you to take the second volume of Authorities, Volume 2, and to go to tab 16, MS 970. Now, this is a Council recommendation of November 2009, which of course postdates the Act. But unsurprisingly, in the preamble, one finds references to the adverse effects of smoking in terms of second-hand smoking, what they call exposure to environmental tobacco smoke, ETS, at paragraphs 3, 4, and 5. A reference to the right of all people to have a high level of health protection and to be protected from exposure to tobacco smoke in paragraph 7. And at 8, a paragraph which reflects what was set out in the white paper about voluntary compliance. Voluntary policies at national level have proved ineffective in reducing exposure to tobacco smoke. Member states' binding legislation properly enforced and monitored is an effective means of adequately protecting people from the health risks of second-hand tobacco smoke. And if you go,
Can I, just for a moment, sorry to interrupt
it's
you,
quite all right.
could I just take you back to the white paper
Yes.
and paragraph 77, which you read out?
Yes, my lady.
So they're announcing that all government departments of the NHS will be smoke-free by the end of 2006. That's obviously before there's any legislation.
Yes.
So that's going to be done by simply government policy in respect of its premises. And then it says we'll use the intervening period of time to consult widely about how actually to frame the detailed legislation, including enforcement mechanisms and penalties and so on. Do we have any of those consultation documents?
My lady,
Were there any?
my lady, the answer to both questions is no, we don't, and I don't know whether there were any. Perhaps is in a better position to assist the court, but certainly we will check that out. Whether the reference to in the beginning of paragraph 77 to the end of 2006 and the end of 2007. Well, I take your ladyship's point in relation to the first bullet point, the end of 2006, and I don't know what, if any, policies were put in place prior to the Act to cover government departments in the NHS. Maybe
Well, it looks as if they're contemplating we will do what we can in our own premises and we will then be legislating for other people's premises. which we will expect to have done obviously by the end of 2007, or at least to bring it in. And indeed they did, the timetable worked. I was just interested in what consultations, if any, there were
Yes.
on the details,
Well,
because they might be instructive
Well, Milady,
either way.
yes. Well, Milady, I can't assist at the moment. We will check that out overnight.
Thank you. Sorry, you can go back to the EU recommendation
thank you very
now.
And then at page, MS page 971, paragraph 14, we find reference to an earlier Council recommendation of 2002 on the prevention of smoking and on initiatives to improve tobacco control, which recommended that Member States implement legislation and or other effective measures that provide protection from exposure to ETS in indoor workplaces, enclosed public places and public transport. So already in 2002, the EU was recommending Member States to introduce legislation along those lines. And then so far as the international position is concerned, can I ask you to go back to the appendix to page 405, MS number 530. Now, this is Article 8 of the, as we'll see if you go back to page 403, Article 8 of the World Health Organization Framework Convention on Tobacco Control, dated 2003. And Article 8 at page 405 provides, 1, parties recognise that scientific evidence has unequivocally established that exposure to tobacco smoke causes death, disease and disability. 2, each party should adopt and implement in areas of existing national jurisdiction as determined by national law and actively promote at other jurisdictional levels the adoption and implementation of effective legislative, executive, administrative and or other measures providing for protection from exposure to tobacco smoke in indoor workplaces, public transport, indoor public places and as appropriate other public places.
What's the status of that framework convention, Mr. Hayes?
Well, it's
Exactly that.
it's a convention to which the UK is signed up,
It's an international obligation, is it?
it's an international obligation we would submit.
And it's in force. The treaty's in force.
Yes, so as I'm aware.
Well, that may depend on
Numbers.
numbers. Okay.
That's right, exactly.
Yeah.
I'll check that as well.
What have we done? Signed it and ratified it?
Nor as I understand it, yes. But
There are
I'll
people with
confirm that as well.
computers behind you who can quickly look this up.
Yes,
They can look up the World Health Organization, and when they publish the treaties, they usually have a table saying who has signed, who has ratified, and when it came into force. We are mindful of the general approach to statutory construction that the UK Parliament intends to legislate consistently with the UK's international obligations. But if there isn't an international
Yes.
obligation because it's not yet in force or because we've only signed it and not ratified it or whatever, well, then that principle wouldn't assist you.
According to the WHO site, it came onto force on the 27th of February 2005.
So it's in
Well, I-
force.
Having been
So it's in force before the 2006 Act.
Yeah.
yes. Well, I've always assumed that it was, but thank you very much for confirming that.
180 countries have ratified, including 43 members in Africa.
And do they include the UK?
Well,
As I say, those with computers behind you can look this up.
Lady and my Lords, that then takes me to the explanatory notes to the 2006 Act. If I could take you back, please, to the second bundle of authorities. And to tab 13. And the explanatory notes are to be found at MS page 919 at the end of the tab.
I'm sorry to be pernickety, Mr. Hayes. So have we got somewhere the date when all this came into force?
Have we got, my Lord?
Have we got the date of commencement somewhere?
Yes, my Lord. The Act itself
2007.
came into force on the 1st of July 2007.
Thank you very much.
It received the royal assent on the 19th of July 2006.
1st of July 2007 is the date. Thank you.
So MS 919, at the end of tab 13, we find the explanatory notes, and can I pick up paragraph 6? Chapter 1 of Part 1 of the Act makes provision for enclosed and substantially enclosed public places and shared workplaces to be smoke-free. This follows the publication of the White Paper in November 2004, which set out the government's proposal to shift the balance significantly in favour of smoke-free environments. The Act would also give the appropriate national authority, Secretary of State in the case of England, and National Assembly for Wales in the case of Wales, powers to make regulations to exempt premises or parts of premises from smoke-free legislation, and then reference to the Act providing powers for appropriate national authority to make regulations to specify additional smoke-free premises.
Nothing about prisons here.
Not yet.
Is the important expression workplaces or not?
It is an important expression because, as we see when we come to the Act, the intention of Parliament we submit was to protect all those who don't smoke in their places of work.
Right.
To protect them from the effects of second-hand smoking. Can I then go on to paragraph 41, which is at page 7 internally of these explanatory notes, MS page 925. Headed Section 3, smoke-free premises exemption. Section 3 enables regulations to be made by the appropriate national authority to specify descriptions of premises or specified areas within such premises which are not to be smoke-free, where they would otherwise be covered by the provisions of Section 2. Subsection 2 gives examples of the types of premises that might be specified under such regulations. These might include, in particular, premises where someone has their home or where they are living, whether permanently or temporarily. Such premises might include places such as rooms in a hotel, bed and breakfast accommodation, a hostel, or a care home. They could also include a place where a person is detained, such as a prison.
Where were you reading from?
My Lord, it's paragraph 41 of the explanatory notes at the top of page 7.
I've got it. Thank you.
But that doesn't do anything, does it, more than simply repeat what you can read in the statute itself?
Well, that is correct, and that's why I'm taking this very shortly.
Thank you.
Before I turn it next to the Act itself. And then paragraph 45, subsection 6 makes provision in respect to the matters such regulations may deal with, including the circumstances and conditions under which and the times at which premises may be exempt. Subsection 7 provides that regulations may also make provision for the designation of rooms in which smoking may be permitted. This would enable provision to be made for designated smoking rooms, for example, in premises such as hotels, prisons, and so on. So a further reference to prisons, as we'll see when we pick up the relevant regulations made under the Act. So can I then turn to the Act, which you will find in, which you will find in the first volume of authorities, at MS 590. While Your Lordships and my Lady are turning that up, can I confirm that the United Kingdom ratified the World Health Organization Convention on the 16th of December 2004?
Thank you.
So the Act itself, Part 1, Chapter 1, Section 1.1, this chapter makes provision for the prohibition of smoking in certain premises, places and vehicles which are smoke-free by virtue of this chapter. And just pausing there, that the scheme, overall scheme of the Act was to identify smoke-free premises and then to make it an offence, first to smoke on such premises, and secondly to fail to prevent smoking on such premises. That's the overall scheme of the Act. So Section 2 provides premises are smoke-free if they're open to the public, but unless the premises also fall within subsection 2, they are smoke-free only when open to the public. 2, premises are smoke-free if they are used as a place of work, A, by more than one person, or B, where members of the public might attend for the purpose of seeking or receiving goods or services from the person or persons working there. They, that's to say, such premises, are smoke-free all the time. 3, if only part of the premises is open to the public or used as a place of work, the premises are smoke-free only to that extent. 4, in any case, premises are smoke-free only in those areas which are enclosed or substantially enclosed. 5, the appropriate national authority may specify in regulations what enclosed and substantially enclosed mean, and that is provided by the 2006 regulations, as we'll see. And then subsection 6, section 3 provides for some premises or areas of premises not to be smoke-free despite this section. 7, premises are open to the public if the public or a section of the public has access to them, whether by invitation or not and whether on payment or not. And then work in 8 includes voluntary work. So Section 2 introduces, we say, a general prohibition on smoking in smoke-free premises.
And are you going to say that prisons are within that because they're workplaces or because they're open to the public or to some sections of the public, or which?
Well, because they are workplaces,
Yep.
they are also open to the public as visitors come to the prisons in order to visit prisoners.
Right. Attend for the purposes of seeking or receiving goods or services. Anyway, you say visitors are public.
Yes.
Right.
So as I was saying, the scheme is that Section 2 introduces a general prohibition on smoking in smoke-free premises, but subject to any exemptions provided from that general prohibition. And Section 3 addresses the question of exemptions. 1, the appropriate national authority may make regulations providing for specified descriptions of premises or specified areas within specified descriptions of premises not to be smoke-free despite Section 2. Descriptions of premises which may be specified under subsection 1 include in particular any premises where a person has his home or is living, whether permanently or temporarily, including hotels, care homes and prisons, and other places where a person may be detained. And then a reference to the power to make regulations not being exercisable so as to specify any description of licensed premises or club premises. 4, but subsection 3 does not prevent the exercise of that power so as to specify any area within a specified description of premises mentioned in subsection 3 where a person has his home or is living, whether permanently or temporarily.
But that's licensed premises, isn't it? So that's not going to apply, is it?
It's not going to, no. 5, for the purpose of making provision for those participating as performers in a performance, so this is addressed to theatres and the like. not to be prevented from smoking if the artistic integrity of the performance makes it appropriate for them to do so. I don't need to read any more of 5. 6, the regulations may provide, in relation to any description of premises or areas of premises specified in the regulations, that the premises or areas are not smoke-free, and then in specified circumstances, if specified conditions are satisfied or at specified times or any combination of those. And then another reference to those conditions may include conditions requiring the designation of any rooms in which smoking is to be permitted. A further subsection addressed to performances, which I don't need to take your lordships through and my lady through in any detail. So that's the general provision for exemptions for smoke-free premises, and we'll look at the exemption regulations in a moment. And then for additional smoke-free places, the appropriate national authority, that's to say the Secretary of State, may make regulations designating a smoke-free any place or description of place that is not smoke-free under Section 2, and subsection 2, the places need not be enclosed or substantially enclosed. And subsection 3, the appropriate national authority may designate a place or description of place under this section only if, in the authority's opinion, there's a significant risk that without a designation, persons present there would be exposed to significant quantities of smoke. So that's the condition which qualifies the power under subsection 1 to make regulations providing for additional smoke-free places. I think I can then turn to section 5 over the page, headed vehicles. The appropriate national authority may make regulations providing for vehicles to be smoke-free. And then 1A, regulations under this section may in particular provide for a private vehicle to be smoke-free where a person under the age of 18 is present. And then 2, regulations under this section may in particular make provision for the description of vehicle which are to be smoke-free, circumstances in which they're to be smoke-free, for them to be smoke-free only in specified areas or except in specified areas, and for exemptions. And we'll see the regulations which have been made in relation to vehicles in a moment.
Why?
Well, only
Are they going to help us answer the
probably,
fascinating question
probably
confronting
not.
us?
Probably not, so I can probably do without them. I'm trying to draw a line between drawing to the court's attention
Well,
those.
it's fascinating, and it answers the questions as to one has when one watches a West End play and so on. But
Yes, well, mercifully, that is not a question for your lordships and my lady to consider. I think I should, however, show you section 6, no smoking signs. It's the duty of any person who occupies or is concerned in the management of smoke-free premises to make sure that no smoking signs complying with the requirements of this section are displayed in those premises in accordance with the requirements of this section. And then perhaps I can go straight to subsection 5. A person who fails to comply with the duty in subsection 1 or any corresponding duty in regulations under subsection 2 commits an offence. And subsection 2, just to pick that up, provides that regulations may be made for a duty in relation to places which are smoke-free and vehicles which are smoke-free. And then over the page, subsection 8, I'm sorry, I ought to pick up subsection 6. It's an offence for a person charged with an offence under subsection 5 to show that he did not know and could not reasonably have been expected to know that the premises were smoke-free, that he did not know and could not reasonably have been expected to know that no smoking signs complying with the requirements were not being displayed, that on other grounds it was reasonable for him not to comply with the duty. And then subsection 8, a person guilty of an offence is liable on summary conviction to a fine not exceeding a level on the standard scale specified in regulations. Section 7, we come to the creation of the offence of smoking in a smoke-free place. In this section, a smoke-free place means, and then your lordship see what is set out. And subsection 2, a person who smokes in a smoke-free place commits an offence. And subsection 6, a person guilty of an offence under this section is liable on summary conviction to a fine not exceeding a level on the standard scale specified in regulations. If it's of interest to your lordships and my lady, the fine, the regulations that have been made provide that the level should be level 1 for that offence, with a maximum fine of £200. And going back to section 6, subsection 8, the regulations provide that the fine should be on level 3, subject to a maximum of £1,000. Section 8 next.
That's not putting up the no smoking signs.
Yeah.
That's
Okay.
correct. Section 8, it's the duty of any person who controls or is concerned in the management of smoke-free premises to cause a person smoking there to stop smoking. Subsection 4, a person who fails to comply with the duty in subsection 1 or any corresponding duty in regulations under subsection 3 commits an offence. Then in subsection 5, the same defence that your lordships and my ladies saw in relation to not putting up the signs. And subsection 7, a person guilty of an offence is liable on summary conviction to a fine not exceeding a level on the standard scale specified in regulations. The level specified is level 4, with a fine up to £2,500. Can I then go to section 9, fixed penalties? An authorised officer of an enforcement authority, see section 10, who has reason to believe that a person has committed an offence under section 6.5, that's not putting up the signs, or 7.2, that's smoking in a smoke-free place, on premises or in a place or vehicle in relation to which the authorised officer has functions, may give him a penalty notice in respect of that offence. 1A, the appropriate national authority may by regulations provide that an authorised officer who has reason to believe that a person has committed an offence under section 8.4 in relation to a vehicle, that's failing to prevent smoking in a vehicle, may also be given a fixed penalty notice. So provision there for the limited use of fixed penalties in relation to some of the offences created by the Act. Section 10, enforcement. The appropriate national authority may make regulations designating persons or bodies or descriptions of person or body which are to be enforcement authorities for the purposes of this chapter, and we'll see who they are in a moment. But broadly speaking, the enforcement authority is the local authority. Subsection 3, it's the duty of an enforcement authority to enforce as respects the premises, places and vehicles in relation to which it has enforcement functions, the provisions of this chapter and regulations made under it. And then subsection 7, Schedule 2 makes provision about powers of entry, and we'll look at that in a moment. Section 11 makes provision for offences in relation to obstructing an authorised officer of an enforcement authority who's exercising his functions, and in relation to failing to give an authorised officer any facilities, assistance or information which he reasonably requires. Subsection 3 provides a further offence in the circumstances there set out, and subsection 4 provides that a person guilty of an offence under that section, again liable on summary conviction only to a fine not exceeding level 3, and the maximum fine under level 3 is currently £1,000. Now, Lords and my lady, can we pick up Schedule 2, which involves going to the second volume of authorities, tab 13, MS number 886.
MS, sorry.
MS 886. Schedule 2, powers of entry. 1, in this schedule, authorised officer means authorised officer of an enforcement authority. Premises includes any place and any vehicle. Paragraph 2, an authorised officer has the right to do any of the following on production if required of his written authority. And then you will see that the following includes entering any premises which he considers it's necessary for him to enter for the purposes of the proper exercise of his functions, to carry out such inspections and examinations as he considers necessary, require the production of any substance or product and inspect it and take and retain samples of it, take possession of any substance or product on the premises and retain it, and require any person to give him such information or afford him such facilities and assistance as he considers necessary for that purpose. Section 3 provides that he can arrange for any substance, product and so on to be tested. Over the page, paragraph 6 makes provision for the authorised officer's written authority. Subparagraph 1, a justice of the peace may exercise the power in subparagraph 3, which we'll come to, if he's satisfied on sworn information in writing that for the purpose of the proper exercise of the functions of an enforcement authority, there are reasonable grounds for entry into any premises other than premises used only as a private dwelling house not open to the public, and B, of either or both of the matters mentioned in subparagraph 2.
Well, that's simply to enforce against an unwilling occupant the
Correct.
powers that you already got under paragraph 2, is that right?
Correct.
Yeah.
And your Lordship is ahead of me. Paragraph 2 then sets out the matters that the Justice must be satisfied of before he can assign a warrant, see subparagraph 3, authorising any authorised officer to enter the premises if need be by force. So those are the, as it were, intrusive provisions which require a warrant by way of written authority from the Justice in the event that permission to enter the premises has been used. My Lords and my Lady, can we stay in this bundle and go next, please, to the explanatory notes which relate to part 3 of the Act, because it's convenient at this stage to show my Lady and your Lordships not only part 3, which I will in a moment, but also the explanatory notes about it. So can I ask you to go to page 15 internally of the explanatory notes, MS page 933, where we find a helpful description of what Part 3, Chapter 1 provides. Headed Supervision of Management and Use of Controlled Drugs. Part 3 of the Act contains provisions intended to strengthen the arrangements for the safe management of controlled drugs in health and social care settings. It provides the legislative underpinning to the programme of action set out in Safer Management of Controlled Drugs, the government's response to the 4th report of the Shipman Inquiry. The key elements are all NHS healthcare organisations and larger private healthcare organisations such as independent hospitals will be required to nominate an officer of sufficient seniority and accountable officer to ensure that the organisation has robust arrangements for the safe and effective handling of controlled drugs. In NHS primary care organisations will exercise this responsibility on behalf of all the contractors with which they've contracted to provide services, and that is the effect of Section 17 of the 2006 Act. Next, a duty of collaboration will be placed on healthcare organisations and on other local and national agencies such as professional regulatory bodies, police forces, the Healthcare Commission and the Commission for Social Care Inspection, requiring them to share intelligence on controlled drugs issues and to coordinate the action they take to protect patients and the public. That's Section 18. And then police officers, accountable officers and their staff and other authorised persons will have a right of entry and inspection into the premises of relevant healthcare providers to enable them to discharge these responsibilities. The power of entry will not necessarily be exercisable by all accountable officers. That's section 20. So with that in mind, can I ask you to go back to volume 1 of the authorities and to tab 1, the 2006 Act, and to pick up part 3, which begins at MS page 601, page 19 internally. Now here we have, in quite complex language, the provisions which were helpfully summarised in that part of the explanatory notes which I've just read out. So section 17, section 18, and then section 20. You will note, if I can take you to section 21 at MS 607, that part 3 creates certain offences in connection with the power to enter and inspect. That's the power set out in section 20. And I don't need to take you through them in any detail, but you will note that under subsection 2, a person guilty of an offence is liable on conviction on indictment to imprisonment for a term not exceeding 2 years or to a fine or both, and on summary conviction to imprisonment for a term not exceeding 12 months or to a fine or to both. And then section 23 at MS 608, and I'll come back to this later in more detail, the Crown application, this chapter binds the Crown to no contravention by the Crown of any provision of this chapter shall make the Crown criminally liable, but the High Court may declare unlawful any act or omission of the Crown which constitutes such a contravention. And then 3, the provisions of this chapter apply to persons in the public service of the Crown as they apply to other persons. So a distinction is drawn in section 23 between the Crown on the one hand and persons in the public service of the Crown on the other hand. Can I then take you to the 2006 regulations? I'm afraid this involves going back to volume 2 of the authorities. And the 2006 regulations begin at MS 963, behind tab 14. Simply to identify for my lady and your lordships the definition set out in those regulations of who are to be designated as enforcement authorities. That's to be found in Regulation 3 at MS 964. And for present purposes, it's sufficient to note that they comprise primarily local authorities. They also include the sub-treasurer of the Inner Temple and the under-treasurer of the Middle Temple. That's another story, perhaps.
Oh, what about Gray's Inn?
Yes.
Lady, I'm wholly unable to explain that disparity to your ladyship.
Because all Gray's Inn members don't smoke.
And never have done, my lord. Can I then finally show you the 2007 regulations?
They have some special status, don't they, the Inner Temple and the Middle Temple? Which,
Not within the area of the local
yes.
authority, that's why.
That must be the reason.
Yeah.
The 2007 regulations,
So they are for planning.
which you will find behind, in Authorities Volume 1, behind tab 2, in passing, you will note, and I'll show you the section in a moment, from the words above Part 1, General, that these regulations were approved by a resolution of each House of Parliament. So the affirmative resolution procedure applies to regulations made under the Act. As I say, I'll show you that section 79.4 in a moment. Not all of them, no. Most of them. Part 2, exemptions. The exemptions in this part apply only to premises that would be smoke-free under Section 2 of the Health Act 2006 if those exemptions had not been made. 3, headed private accommodation. A private dwelling is not smoke-free except for any part of it which is A, used in common in relation to more than one set of premises, B, used solely as a place of work by more than one person who does not live in the dwelling, to a person who does not live in the dwelling and any person who does not live in the dwelling, or 3, a person, whether he lives in the dwelling or not, who in the course of his work invites persons who do not live or work in the dwelling to attend the part of it which is used solely for work. Regulation 4 is addressed to accommodation for guests and club members and uses the scheme of designating a bedroom in such premises. Regulation 5, paragraph 1, a designated room that is used as accommodation for persons aged 18 or over in the premises specified in paragraph 2 is not smoke-free. And paragraph 2, we see, specifies those premises as care homes, hospices, and then C, prisons. So designated rooms in prisons are not to be smoke-free.
Basically, cells for people over 18.
Yes.
Got it.
And then we see from...
And perhaps, I suppose, any other rooms used by people over 18? Accommodation, does accommodation mean sleeping?
Well, it will do, yes.
Only?
I don't think it's defined, my lord.
Okay. Well, there we are.
But certainly what is clear is that that the exemption will only apply to a designated room being used as accommodation, and a designated room is defined in paragraph 3 as meaning a bedroom or a room used only for smoking, which has been designated in writing and has a ceiling and so on.
The inference is that accommodation is not just sleeping, because if you look at 4.2a, it refers expressly to sleeping accommodation.
Yes.
Yeah, that's right. But they have to be designated in any event under 5.
Yes.
Yep.
And then paragraph 3 continues, so just picking up the opening words again, in this regulation, designated room means a bedroom or room used only for smoking, which, and then E, except where the room is in a prison, does not have any door that opens onto smoke-free premises, which is not mechanically closed immediately after that use. So this is 5.3e.
Oh, it's up there, yes, I'm sorry, yeah.
Then under, just to see the extent of the exemptions made by the regulations, we see a further reference in Regulation 6 to the exemption for performances, theatrical performances, where it's appropriate for the person taking part in the performance to smoke. Regulation 7, specialist tobacconists. Regulation 8, offshore installations. Regulation 9, research and testing facilities. And then Regulation 10, a brief, because it expired the following year, temporary exemption for mental health units. And then Part 3, vehicles. Enclosed vehicles, subject to the following paragraphs of this regulation. Enclosed vehicle, and in the enclosed part of a vehicle, is smoke-free if it's used, and then your lordships and my lady will see the requirements in relation to vehicles there set out. So the only exemptions, just to identify them, provided for under the Act and the regulations, are a private accommodation, if one can put it in that way in very general terms, designated rooms in hotels and the like, designated rooms used as accommodation in care homes, hospices, prisons, and offshore installations, theatres and the like, where the artistic integrity of the performance makes smoking appropriate, specialist tobacconists, research and testing facilities, and vehicles being used solely for personal use. Now, before I turn to the cases, can I just show the court some further materials in the appendix relating to the a plain understanding of the sponsoring department, the Department of Health, and indeed the prison service, as to whether the Act bound the Crown or not. Can I ask you to go to page 284 of the appendix, MS 409. This is dated the 1st of July 2007. It's online, published by the NHS, the Smoke-Free England department thereof, and it reads, to the extent that you're able to decipher it from the very small type, A Healthier England from July the 1st, 2007. On July the 1st, 2007, England introduced a new law to make virtually all enclosed public places and workplaces in England smoke-free.
I know the internet is always accurate, but who is this?
This is the NHS Smoke-Free England site.
And it's totally inadmissible as a matter of law, is it?
Well, my lord,
But anyway, it's just consistent with your case.
well, it is. There is a justification for my showing your lordships and my lady this material, in that in paragraph 68 of the respondent's case, I don't invite you to turn it up, but the reference is MS 116, he says that the government's policy in relation to prisons is independent of the provisions of the 2006 Act. But as we'll see when I go to the next two extracts in the appendix, that doesn't appear to be correct. That the next reference is at page 445 of the appendix, MS 570. And as we see from the top of the page, this is a document published by the Department of Health, left-hand side, Her Majesty's Prison Service, and the University of Stirling. And if we go to page 447 of the appendix, MS 572, and we see the foreword, which is by the Director of Prison Health at the Department of Health and the Deputy Director General of Her Majesty's Prison Service, the last paragraph of which reads, legislation which comes into effect in England in July 2007 to control smoking in all enclosed public places means that in future adult prisoners will only be able to smoke in their cells or in the open, and staff will not be able to smoke anywhere within prison buildings. We see this as an opportunity to improve conditions within prisons for all who work or live there.
Sorry, could you just give me the page reference?
Yes, 447, and the MS page is 572.
572.
So you say they thought the legislation applied?
Plainly so. And they being the Department of Health, the sponsoring department of the legislation, and the Deputy Director General of the State Prison Service, with whose prisons, state prisons, this appeal is fundamentally concerned. And then the final reference is back to page 304 of the bundle of the appendix, MS 429. Now this is the then current PSI, Prison Service Instruction. We can see from the top left-hand corner that the stamp, as it were, HM Prison Service. Title, Smoke-Free Legislation, Prison Service Application. Implementation date, 2nd of April 2007. Contains mandatory instructions for action governors and prison, and I did know what HCCs stand for, but I can't now recall. And then on the authority, right-hand column, on the authority of the Prison Service Management Board. And then at the foot of the page, notes this PSI is for use in establishments in England only. And then across the page, page 305, smoke-free legislation, application, smoking cessation. And then the Smoke-Free Legislation, Health Act 2006, takes effect from 1 July 2007. This PSI will require all prisons to have a new smoking policy implemented and active by 2nd of April. Broadly, the regulations will require all indoor areas to be smoke-free, with the exception of cells occupied solely by smokers aged 18 and over, and so on. And then towards the foot of that page, the heading, Local Policies will need to implement the following to meet the requirements of the Act. Over at page 306, MS 431, towards the top of the page, after the 2 bullet points, the law will require that no other parts of buildings may be designated as smoking areas. This means that any current smoking rooms will no longer be acceptable for staff or prisoners. Para 6, staff smoking. The policy on when and where staff may smoke should already be in place, but it is to be reviewed in the light of the legislation which provides the policy with the force of law. Then 7, signage. Specifications for signage are at Annex 1. Governors must arrange for the appropriate signage to be displayed, and we'll look at that in a moment. And then paragraph 13, governors will arrange for staff to be briefed on the requirements of the legislation and how it will be applied and implemented within their establishment. And then if we go over to 308, MS 433 at the top of the page, guidance notes for clarification of information in and then reference to this PSI. And then page 309, the legislation is the heading, and then what follows, we see a summary of the legislation, this being Annex 1. And I can pick up in particular 4, under the legislation there will be no legal obligation for governors to allow smoking in cells. 5, as a result of the clauses on exemptions, prison service policy is that cells holding prisoners 18 years or more will be designated smoking areas, and then signage, the exemptions allowing smoking in designated areas will lie in clause 3 of the legislation. The appropriate signage in this case is, and then your lordships, my lady, will see the 3rd bullet point, a sign must carry the following words in characters that can be easily read: no smoking, it is against the law to smoke in these premises except in a designated room.
Does any of it say anywhere or give guidance anywhere about cooperation with the enforcement authority?
No, not that I
No,
can, not that I can recall.
you'd have seen it if
specific-
it did. Yes, okay, thank you.
I'm sure that Parliament will have expected the enforcement authorities to seek cooperation with bodies about whom they are concerned in terms of enforcing the Act, but I can't recall any specific provision in the Act or the regulations.
No, I meant in the PSI.
Yeah, oh, in the PSI.
For governors. But
I'm so sorry.
You'd have told us if it did, I'm sure.
We'll look, and if we find it, we'll tell you.
Yeah.
So, as I say, the prison service itself seems to have understood quite clearly that the legislation applied to state prisons. Can I then turn to the cases? My lady and my lords, there are a significant number of cases that, as it were, predate Bombay and then most recently Dumbarton. I propose to try to restrict myself to what seemed to us to be the most relevant or the most helpful. I know my own friends have cited some other of the...
Well, no doubt you will rely on the ones you consider most helpful, and Mr. Reedy will rely on the ones he considers most helpful.
No doubt he will. But I say...
It's the way of the world.
It is the way of the world. But I've said what I have just to indicate why we are only going to refer you to some of them. And I'm going to try and make the exercise reasonably expeditious. But can I begin with Gorton, which is in volume 3 of the authorities, behind tab 19. And in a paragraph, can I just indicate the factual background to the case? The prison commissioners...
It would help to have a page reference.
I'm so sorry, MS 1003.
Thank you.
I do apologise.
Cooper and Hawkins?
No, Lord Gorton.
Oh, sorry.
Gorton Local
Yes,
Board
got
of
it.
Prison Commissioners. And in a paragraph, the commissioners had erected some houses and other buildings on part of a plot of land next door to a prison to be used as officers' quarters. The plot of land fell within the district of the local board. After the buildings were erected, the board applied to the prison governor to allow them to be inspected to see if they were fit for habitation. There was a bylaw which provided that no new house should be occupied until the board had certified it as fit for human habitation. The application was refused, so the board took out a summons before the magistrates to enforce the bylaw. The summons was dismissed by the magistrates, but they stated a case. And the questions for the court included the question whether the commissioners were bound by the bylaws, and therefore whether penalties for breach of the bylaws could be enforced against them. There were two judgments, the first being the judgment of Miss Justice Day, beginning at the foot of the right-hand column on MS 1004. Can I pick it up in the left-hand column on MS 1005, about a third of the way down? But upon the other point, I entertain a different opinion. Pick it up 3 lines further on. I'm not quite sure whether this point was raised before the magistrates or not. It is raised upon this special case, and with it we have to deal. I am clear that, having regard to this point, the decision of the magistrates must be upheld. It is clear to my mind that this plot of ground is state property, and it is property, therefore, in my judgment, over which the local authority can have no control whatever. It is property provided by the Crown, if I may use that expression, for the purposes of the Crown, and it is occupied by servants of the Crown. In my judgment, that property is to be entirely under the control of the Crown and is not to be controlled by the local authority. There is certainly no express mention of the Crown so as to bind the Crown in the Public Health Act 1875, and there is certainly no necessary implication that the Crown itself is to be bound. In the absence of express words, the Crown is not to be bound, nor is the Crown to be affected except by necessary implication. There are many cases in which such implication does necessarily arise, because otherwise the legislation would be unmeaning. That is what I understand by necessary implication. Here the Crown is not mentioned, and no necessary implication of any sort or kind arises, and it is clear that the Crown, by its officials, is quite competent to provide for the sanitary condition of these houses. It's quite competent to do all that it thinks fit to be done in the matter, and it is not to be controlled. That is, to my mind, a matter of the greatest public interest. The state is not to be controlled in the disposition of the property entrusted to the state for state management by any local authority whatever.
As a matter of fact, that must have changed subsequently, because when we set up this court, we had a considerable amount to do with Westminster City Council in relation to planning. Presumably, I mean, maybe it's all expressed in the statute, but I don't know whether you can avoid the Building Act inspectors as well if you belong to the Crown.
Well, I can't help us to the present position. The current
No, it's just in that respect, it seems to be a very historical decision.
It is, but as one can see from his judgment, that judgment was very much founded on the proposition that state property is not to be controlled by a local authority, and then he ends up. That's the ground on which the decision of the magistrate must be upheld. And so, picking up what I've just said, he begins his judgment on this issue by reference to the fact that, or the principle that that state property is not to be controlled by the local authority, because it's to be controlled solely by the Crown, and he concludes his judgment on that basis, and thus we would submit what he said about the legislation being unmeaning has to be understood in that context. The other judgment was given by Mr. Justice Wills. Can I pick that up at the foot of the second column on MS 1005? A far more serious and important question is whether the bylaws were intended to apply at all to property held for public purposes in the fashion and in the circumstances under which this property is held, whether by the Secretary of State or by the prison commissioners. It is clear that this is property of the Crown in the sense in which that expression has always been used when questions of this kind arise as to the rateability of property. And then I don't trouble you with the rest of that paragraph, save for the final sentence. It is property held and administered by the Crown for the service of the public. So he makes the same point at the outset of his judgment. In my judgment, however anxious one may naturally be to confine the application of the prerogative within its legitimate limits, it seems to me that it's clear from authority and from principles which are established beyond cavil and dispute that the Crown is not bound unless it is expressly or by necessary implication named. How can it be said here that there is a necessary implication of the Crown? It is not necessary, as it seems to me, for the purposes of the public health and public good, which are intended to be served by the Public Health Act, that this jurisdiction should be vested in the local board. In the year 1865, substantially the same legislation with regard to the possibility of the enactment of bylaws by local boards was in existence, and in that year was passed the Prison Act, which enacts, amongst other things, by Section 26, that the Secretary of State may approve of the plans submitted to him with or without modification, or may disapprove of the same. And there's no doubt that the subject matter to which these plans may relate is large enough to cover such a building as this. There is therefore a high and responsible officer of the state in whom is vested the discretion of approving or disapproving of such plans, and in whom was vested that discretion at a time when these bylaws, and a great many other bylaws of a similar character, must have been in force under the Local Government Act of 1858. Can anybody suppose that it was intended that the approval of the Secretary of State should not be effectual, and that because the locus in quo was situated within the area of the jurisdiction of a local board, although the Secretary of State approved the plans which he approved of should not be followed out? Seems to me something like an absurdity to suppose such a thing, and there's certainly as much reason in legislation giving credit to the Secretary of State that he would do his duty and would see that the great interests of the health of the public were regarded as in supposing that the local board in each district would do its duty. The protection of the public is as complete and as effectual as under the approval or disapproval of the local board. Well, that was the state of things down to 1875, and then he essentially says that the 1875 Act doesn't change the position which existed in relation to the 1865 Act, notwithstanding that it repealed all the prior legislation. It may be true that legislation took, in a certain sense, a fresh departure in point of form from that period, but can anybody who is familiar with the course of legislation and of these public health acts suppose that simply because the Act of 1865 is subsequent to the Prison Act, it was intended that there should be any change wrought in the effect of legislation in this respect? It seems to me that the Public Health Act 1875 leaves untouched this prior legislation applicable to prisons in general, and although this place was not popularly a prison, yet it certainly was under the Prison Act, a prison subject to the provisions of that Act. And it seems to me that it is impossible to suppose it was intended to take away from the Secretary of State that jurisdiction which he had before finally and authoritatively and effectually to approve, if he chose, of the plans which were to be submitted to him. So, just pausing there, the steps we suggest in Mr. Justice Will's reasoning were firstly that it wasn't necessary for the purposes of public health and the public good for the jurisdiction of the Public Health Act to be vested in the local authority, the local board, because of the parallel legislation, that's to say the Prison Act of 1865, which provided parallel protection by way of the Secretary of State having to approve plans submitted to him. So we suggest important to understand that the judge's reasoning was dependent on there being a parallel scheme or a parallel statutory scheme under the Prison Act 1865, which in the sense of providing or protecting the public health and the public good provided a similar protection, and that he held remained the position notwithstanding the Public Health Act of 1875. Can I just draw to your attention the final paragraph of Mr. Justice Will's judgment at the foot of the right-hand column on MS 1007. For these reasons, it becomes unnecessary to express any opinion as to whether the prison commissioners or the Secretary of State would be formally the proper persons to bring before the magistrates, because I am of opinion that these proceedings cannot in any shape succeed against the Crown or against the commissioners. So what he would then have gone on to consider was who should be liable under the bylaw, should it be the Secretary of State or the prison commissioners, and who therefore should have been liable potentially for penalties were there to have proved a breach of the bylaw. What's interesting, we suggest, about this case is that neither the Attorney General, who argued the case for the commissioners, nor the court made any reference or suggested in any way that one reason why the Crown was not bound by the Public Health Act was that were it to be bound, the Crown would be exposed potentially to penalties. That's to say, the penalties that could be enforced for breach of the bylaws. And I'll explain the significance of that a little later when I address the respondent's point as to criminal liability. So, my lady and your lordships will see that the reasoning of the two judges in that case, which is, we suggest, specific to the facts and the parallel legislation which applied. Can I then go to Hornsey against Hennell, which is in the same bundle behind the next tab 20, the Hornsey Urban District Council in its MS 1008 against Hennell. I can take this much more shortly. If one the case concerned the question whether the Crown was bound by the second of the two acts in play in the previous decision, the 1875 Public Health Act, specifically section 150, in respect of land purchased and owned and occupied for the purposes of a volunteer corps. And I can go straight to the judgment of Lord Ulverston, the Chief Justice, with whom it was his judgment and the judgment also of Mr. Justice Darling and Mr. Justice Chanel at page 80 internally, MS 1015. And can I pick it up about 6 lines into the first complete paragraph? This is, in our opinion, an ownership and occupation for and on behalf of the Crown, and the appellants must show some words which impose upon the Crown an obligation to do the work or pay the expense of it. The principle that Acts of Parliament do not impose pecuniary burdens upon Crown property unless the Crown is expressly named, or unless by necessary implication the Crown has agreed to be bound, is, in our opinion, still applicable to such a case. No doubt the insertion in many Acts of Parliament of clauses to protect the Crown or save Crown rights has given rise to the impression that this rule has to some extent been trenched upon. We are far from saying that there may not be provisions in public Acts of Parliament so framed as to bind the Crown, even though the Crown may not be specially named. But in our opinion, the intention that the Crown shall be bound, or has agreed to be bound, must clearly be either from the language used or from the nature of the enactments, and there is, in our opinion, nothing of the kind in the provisions of the Public Health Act to this case which gives rise to any such presumption. Just
What's the rationale for this principle?
well,
Why shouldn't the Crown, if it may be that it's a product of an era when the Crown didn't own a huge amount of property? But,
well, Lord, with respect, we asked the same question rhetorically, but it may be that the rationale is found in the opening words of that passage, because he begins by saying, this is, in our opinion, an ownership and occupation for and on behalf of the Crown, which harks back, we suggest, to the Gorton case and the reliance there by both the judges on the fact that the land in question was Crown property. But then he goes on, the principle that Acts of Parliament do not impose pecuniary burdens upon Crown property unless the Crown is expressly named appears to be something of a throwback to the earlier grounds upon which Crown immunity was allowed, namely whether the act in question would affect the prerogative of the Crown or impose on the Crown any burdens. So both those references, or both those sentences may be harking back to the earlier justifications for Crown immunity. But other than that, there's nothing there to indicate the justification for a general immunity of the Crown. My Lord and my Lady, I go next to Cooper and Hawkins, which is behind the next tab in the bundle, tab 21, MS 1018. I can pick up the factual background from the headnote. By the Locomotives Act 1865, power is given to local authorities to make regulations as to the speed, not in any case to exceed 2 miles an hour, at which locomotives may pass through the place subject to their jurisdiction. And by Section 4, it's provided that subject to those regulations, it shall not be lawful to drive any such locomotive along any turnpike, road or public highway at a greater speed than 4 miles an hour, or through any city, town or village at a greater speed than 2 miles an hour. So those were the facts, and the appellant was summoned before justices on an information accusing him of having unlawfully driven a locomotive along a public highway at more than 2 miles an hour. And we see from the foot of that page that he was driving it at a speed of over 3 miles an hour, that the locomotive was the property of His Majesty, and the appellant, looking over the page 1019, was driving it in the course of his duty, and in accordance with the instructions of his superior officer, the coal in the truck being required for use that night in the balloon factory. Lord Alveston was again presiding, and if I can take you to page 170 internally, page MS 1024, he begins by saying, upon the general question of when statutes should or should not be held to bind the Crown, I cannot add anything to that which I said in the Hornsey case. And then can I pick it up over the page? I'm asked to read the beginning of the next paragraph. If it should be thought necessary to report this case, I think it's very important that the judgments of Mr. Justice Day and my brother Wills in Gorton should be reported, because if I may be allowed to say so, they are of very great value upon this question.
And in fact, they were reported by way of footnote 3 to the report.
As my lady has spotted, yes, they were. Can I go then to internal page 171, MS 1025? Now, this is in response to a submission that since the object of the Act was to protect the public, it ought to be held to bind the Crown. And that, in the first complete paragraph on 171, MS 1025, Lord Alveston says, speaking only for myself, I do not think that section, looking at its language and its objects, and at the power given the local authorities to vary it, can be said to be a general enactment of the character to which Mr. Russell has referred. And at this point, can I hand up to my lady and your lordships a short supplemental bundle for today's purposes? You've got this, haven't you? It's only the material we sent them yesterday.
Any question of any nuisance?
Sorry, I think. And invite you, please, to go to tab 2, where we find the Locomotives Act 1865, and where we can see the whole of section 4, because otherwise what Lord Alveston has just said about the power given the local authorities to vary section 4 won't make any sense. So page 101, if you would take the numbering from the top right-hand corner, the Act beginning at the foot of page 100, 101, just over halfway down the page, section 4, subject and without prejudice to the regulations hereinafter authorised to be made by local authorities. Then we see it shall not be lawful to drive, and I don't need to read out what is prohibited, but can I also draw your attention to the final words of the section, and any person acting contrary thereto shall for every such offence on summary conviction thereof forfeit any sum not exceeding £10. There is an extract from the section in footnote 1 of the report at MS 1019, but neither the opening words nor those concluding words of section 4 are to be found in that extract. So one of the factors that Lord Alderson took into account was that, perhaps somewhat surprisingly, but Section 4 was subject to regulations made by local authorities.
Sorry, meaning what? That they could provide for a different speed limit.
Yes, I think that must be it. I mean, Lord Alderson described it as the power given local authorities to vary it.
Yeah.
And my Lord, I think that has to be the meaning.
So the offence is the offence contrary to Section 4.
Correct.
Okay.
Which provided for a fine of up to £10.
But the variation is, we haven't got it, but it looks as if it's permitted under Section 8. We've got it at the bottom of the page.
Yes.
It says the following local authorities, then it defines the local authorities, but we don't have the rest of it, unfortunately.
Well,
but it looks as if that's the one that gives them the power to do something else.
Lady, we will bring the rest of Section 8 with us tomorrow.
But it isn't
Yes.
to do. It isn't the case. Cooper and Hawkins isn't principally about, at least as far as one can see, the powers of the local authority
No, it's not. But
to fix speed limits. It's about whether Section 4 applies to a locomotive that belonged to His Majesty.
Correct.
Yeah.
But I wanted to show the court the whole of Section 4 because of the reference to a penalty being available for breach of the provision in the context of the respondent's criminal liability argument. And it's also to be noted that the opening words do explain what Lord Alderson was referring to in the passage I've just read you. I need say no more, or take no more time.
Again, one asks oneself, are the Road Traffic Acts careful to provide that Crown servants are not allowed to drive faster than the 10 miles an hour, which is, I think, the lowest that Camden Council has reached in our area.
They probably do, actually.
I mean, this is...
Well, my Lord, 10 miles an hour is, I think, almost the average speed of any vehicle travelling through London generally.
No, it's less
No,
than
it's
that.
much less than that.
It's less than that, right.
Yes.
You're very lucky.
You're very lucky in Camden.
We'll get down to 2 miles in due course.
Can I, going back to what the case was really about, go back to page 171 internally, MS 1025. And at the foot of that page, we see Lord Alderson saying this: I think that in a case which has solely reference to the use of a Crown locomotive by a Crown servant in the performance of military duties, we ought to hold that the section does not prohibit that act and does not bind the Crown in that sense. It is perfectly obvious there must be many occasions when in the performance of military duties it would be absolutely necessary for locomotives to be driven at a greater speed than 2 miles an hour. I mention that not only for the purposes of enforcing the argument, but of pointing out why there is no general principle why such a section should be held to bind the Crown. So that represented his reasoning, and then...
The answer is, if it's of any interest to Lord Mance's question, is that Section 183 of the Road Traffic Regulation Act 1988 does specifically apply to the Crown and vehicles in its ownership.
No, thank you.
The reasoning in the top of the page it does rather overlook the fact that the same is true of the police now, but they're not part of the Crown. Presumably there is some specific alleviation in respect to them if they have to exceed the speed limit, but I don't know.
I think there must be.
There is. And ambulances.
Well, that was as a result of it holding that they weren't. It wasn't, so it was introduced. Yeah. You have to look up each of these pieces of legislation to which you're referring, Lord Mance. You'll have to look them up and find out the answer.
I'm not going to take that challenge on.
Well, I'm going to try to avoid doing so if I can.
Well, there are some pieces of legislation that the Crown volunteered to be bound by, even though it wasn't. And that used to be the situation in relation to planning. It may now be governed by legislation, but that certainly used to be the position.
Yes. Then, so far as Mr. Justice Will's judgment was concerned, he begins, I'm entirely of the same opinion. I cannot help thinking that the fact that the section would, at the will of the local authorities, subject the persons who are engaged in the performance of duties of this kind to liabilities which at the time this Act was passed could not be known or foreseen, is a strong argument against the supposition that the Crown consented beforehand to allow itself to be bound by an Act of Parliament which provides for bylaws which may be imposed by local authorities. I do not know that there is any decision on the exact point. I rather think that there is not, but I think that the fact of there being a power in an Act for a local authority to make bylaws is a strong argument. I do not say it's conclusive, that there may be other considerations which outweigh it against holding that the Crown is bound by it. I agree with my lord that this is not one of those enactments of paramount importance to public safety which require that a great public department should be responsible if its servants in the performance of their duty and acting under orders should exceed the rate of speed which is provided for. And I cannot help thinking that many of the considerations relied upon in the judgment of my brother Day and myself in the case which has been cited are quite correct, in principle and founded on very sound reasons. I cannot help thinking that they apply here, and apply, it seems to me, with rather more than usual force, because this is an Act of Parliament which, if it binds the Crown, must bind all the great departments of state, no matter what they are, and therefore must bind the military department. Now, the military department is of a character that to have this kind of interference might hamper the military service exceedingly. He then gives some examples, and then in the next paragraph continues, these are mere illustrations, but they tend to show that this is not an enactment which ought to be held to bind the Crown. So your Lordships and my Lady will see that the decision was very much based on the fact that were the Crown to be bound, there would be adverse consequences in terms of the performance of military duties.
What were the bylaws which he was worried about?
Speed limit fixing.
Just fixing the speed limit.
Well, basically, that's why Section 8 is interesting.
Yes.
Section 8 clearly gave the local authority power to modify Section 4, presumably by setting a lower speed limit.
Yes.
Or lower or higher, I imagine. Well, it might be either. But anyway, they can certainly fix the speed limit, and that's one of the things that Justice Wills refers to. He also says that this is not one of those enactments of paramount importance to public safety which require application to the Crown. So, presumably he's recognising that some might.
Yes, very much so. And it seems clear that both the judges took into account that the ability of the local authority to make bylaws which would affect the speed limit, and this harks back to Gorton, we suggest, and took the view that in circumstances where a local authority can make bylaws which would vary or override a statute, then it would not be appropriate for the Crown to be bound.
The alternative view is it might be that local authorities are very well placed to decide what local conditions require.
Yes, my lord.
And
Well,
I think the anomaly was that the local authorities should have power to bind the Crown. I mean, they may well be best placed to reflect local conditions, but they shouldn't have the power to bind the Crown.
I'm not sure it's got anything to do with local authorities, you know, Mr. Hayes. If you look at page 1018, the offence he was charged with was exceeding the 2 mile an hour speed limit, which is the statutory speed limit. Because it was through Aldershot, and through towns the limit by the statute is 2 miles an hour. It's 4 miles an hour outside, and 2 miles an hour through any city, town or village, which I imagine Aldershot probably qualified as.
Yes, probably was.
Yes, but the head note seems to lay emphasis on the power given to local authorities to make regulations.
Well, it does. But that's not what he was charged with. He wasn't charged with offending a separate
No, he wasn't.
local authority assessed speed limit. He was charged with exceeding the statutory speed limit. There we
Well,
are.
that's right, but it seems clear that what the court objected to was the fact that the Crown might end up being bound by
Yes.
a variation of
Yeah.
of Section 4 and the speed limit set out in it.
I mean, it's quite a hierarchical view of the relationship between the Crown, the executive, and a democratically elected local authority.
No, that is certainly true, and perhaps that reflected
Yes, I mean,
conventions and thinking at that time, which was, as one sees now, some considerable time ago. That takes me then to the Bombay case, and I'm so sorry, before leaving Cooper and Hawkins, can I just make the same point in relation to criminal liability? As you've seen, the section provided for a fine of up to £10 in the event of a breach of the speed limit, but neither the Solicitor General, who argued the case on behalf of the employee, the Crown employee, the driver, nor the court relied on any argument that the Crown wasn't bound, because to do so would have exposed it to the threat of criminal liability. Lords, can I then turn to the Bombay case, which is in Volume 1 of the Authorities bundle, behind tab 3, MS 618. And the headnote, the first paragraph of the headnote, conveniently tells us what the factual background was. The Crown is not bound, either expressly or by necessary implication, by, and then a reference to various sections of the City of Bombay Municipal Act, which in effect give the municipality power to carry water mains for the purposes of water supply through, across, or under any street, and into, through, or under any land whatsoever within the city. And that was the question. Was the Crown bound by those statutory provisions? And the judgment of the Privy Council was given by Lord Du Parc. And can I take you to page 61 internally of the report, MS 621. And the first complete paragraph, about 7 lines in, the general principle to be applied in considering whether or not the Crown is bound by general words in a statute is not in doubt. The maxim of the law in early times was that no statute bound the Crown unless the Crown was expressly named therein. And then a reference to the King not being bound by any statute unless expressly named. But the rule so laid down is subject to at least one exception. The Crown may be bound, as has often been said, by necessary implication. If, that is to say, it is manifest from the very terms of the statute that it was the intention of the legislature that the Crown should be bound, then the result is the same as if the Crown had been expressly named. It must then be inferred that the Crown, by assenting to the law, agreed to be bound by its provisions. Can I then take you on to page 63 internally, MS 623. Now this is, the passage I'm going to show to you, my lady and your lordships, was in the context of an argument being advanced, beginning at the foot of the previous page, that whenever a statute is enacted for the public good, the Crown, though not expressly named, must be held to be bound by it. And about just over halfway down the page at 63, he says, their lordships prefer to say that the apparent purpose of the statute is one element and may be an important element to be considered when an intention to bind the Crown is alleged, if it can be affirmed that at the time when the statute was passed and received the royal sanction, it was apparent from its terms that its beneficent purpose must be wholly frustrated unless the Crown were bound, then it may be inferred that the Crown has agreed to be bound. Their Lordships will add that when the Court is asked to draw this inference, it must also always be remembered that if it be the intention of the legislature that the Crown shall be bound, nothing is easier than to say so in plain words. Now, this appears to be the first reference in the cases to the expression wholly frustrated, and therefore to the test, if that is not to put it too high, that it must be apparent that the beneficent purpose of the act, the purpose of the act, would be wholly frustrated unless the Crown were bound. But it must be open to some doubt whether the Privy Council intended that to represent a further test over and above the test of necessary implication, because at the foot of page 64 internally, MS 624, having referred to the position in Scotland, about 5 lines up from the bottom of the page, their Lordships have accordingly considered the question before them in the light of the principle as they have stated it. In so stating it, their Lordships believe that they've done no more than express in their own words a well-settled proposition of law, and they need only refer in addition to the cases already cited to, and then the 2 cases your Lordships have just, and my lady have just looked at, and then over the page, after full consideration, their Lordships can find no reason to say that by necessary implication the Crown is bound by the relevant sections of the Municipal Act. So Lord Du Parc and the Privy Council then revert to the simple test of necessary implication without suggesting that any gloss should be put upon it along the lines of a further test of wholly frustrated, to use a shorthand.
Well, one way of looking at it is to consider whether the entire frustration of the beneficent purpose might conduce to the conclusion that it was necessarily implied.
Well, that seems to, the test now seems to be, and the test applied by the Court of Appeal, is a very strict test to the effect that, in so many words, unless it can be shown that the purpose of the act would be wholly frustrated, then effectively the Crown isn't bound by the legislation.
Well, I think the way that I was expressing it was the converse of that, that if it can be shown that the beneficent purpose would be wholly frustrated, that would be an indicator that by necessary implication the Crown was bound. And presumably your attack on the rationale of the Court of Appeal is that it elevates the frustration of the beneficent purpose to an independent test and looks at it through the wrong end of the telescope.
That is correct. That is one of our criticisms. That takes me finally then to the Dumbarton case behind the next tab 4 in the same bundle.
It's also rather odd, the Privy Council, in saying if it's, the beneficent purpose is wholly frustrated, then it may be inferred that the Crown has agreed to be bound.
Yes.
That's an old-fashioned way of looking at it too.
Yeah.
It is. So I come then to the case where, or in which, Crown immunity was last considered by this court, or the House of Lords as it was. And in order to understand the factual background, can I just read the first part of the headnote, the MOD, in order to carry out work...
Have you given us a page reference?
I'm so sorry, my lady. It's MS 626.
Thank you.
I've got all the references written down, but I'm sorry not to read them out. So MS 626,
Tab 4.
the MOD, in order to carry out work to improve the perimeter fence of a submarine base in Scotland, proposed to cone off 1 mile of a carriageway of the adjoining public road for the storage of portable workmen's cabins and other building material during the work. The local roads authority informed the ministry that its formal permission was first required under a 1984 Roads Scotland Act. The ministry replied the act didn't bind the Crown or its contractors and proceeded to cone off the road and begin the works. So the authority served on the ministry a notice purporting to be given under section 87 of the Act, ordering the reinstatement of the road, and in addition, the local planning authority, whose permission had not been sought, served an enforcement notice and a stop notice under sections of the Planning Scotland Act, 1972. So those were the background facts. Can I take you to the judgment, or the speech rather, of Lord Keith, with whom all the other members of the committee agreed, and begin by taking you to page 586 internally, letter E, MS 632. Where he sets out section 59 of, this is the 1984 Act, which provides for the prohibition on placing or depositing in the road so as to cause an obstruction anything without permission. And then you will note that at subsection 2, a person who contravenes subsection 1 above commits an offence. And so I invite you to note that in passing. I'll come back to the relevance a little later. But then then you will see that Lord Keith conducts an extensive survey of the previous authorities, some of which I've shown to your lordships and my lady already. And can I go to internal 591 MS 637 at letter E? Because he begins his detailed survey with the introductory words, so it's appropriate to turn for assistance to the more modern English cases where the present issue is being considered. In my opinion, the law has developed to a point where it's not helpful to refer to writings of greater or less antiquity which discuss the prerogatives of the Crown. We of course, have attached to our case, as Annex 1, a brief summary of the history of Crown immunity, but we see that Lord Keith decided to begin with more recent English cases, and he began, as I have done this morning, with Gorton. And then we'll see that by the time of page 597, letter E, he has arrived at BBC against Johns, and I only draw your attention to it because at the foot of that page he cites from Lord Justice Diplock's judgment, the last 3 lines: the modern rule of construction of statutes is that the Crown, which today personifies the executive government of the country and is also a party to all legislation, is not bound by a statute which imposes obligations or restraints on persons or in respect of property unless the statute says so expressly or by necessary implication. In my opinion, this statement by Lord Justice Diplock accurately and correctly expresses the effect of the authorities. I consider it to be no longer a tenable view that the Crown is in terms bound by general words in a statute, but that the prerogative enables it to override the statute. As to the considerations which may be applicable for the purpose of finding a necessary implication that the Crown is bound, it's clear that the mere fact that the statute in question has been passed for the public benefit is not itself sufficient for that purpose. Can I then move on to page 600 internally, MS 646, just above letter C. 4 lines in section 59(1) does not bind the Crown expressly, nor does it do so by necessary implication. Nothing to indicate that if the Crown were not bound by it, the purpose sought to be achieved by the enactment would in any material respect be frustrated. Just pausing there, he puts it rather differently to would be wholly frustrated, as we see. Then he goes on, in addition, there are, in my opinion, certain positive indications in the 1984 Act that the provisions founded on were not intended to bind the Crown. And then he refers to those indications. And then finally, can I take you to page 604 internally? Just below letter C. Now, by this stage, he's been considering the position in Scotland and the judgments in the Scottish courts from which this was an appeal. And at letter C, he says, accordingly, it is preferable, in my view, to stick to the simple rule that the Crown is not bound by any statutory provision unless there can somehow be gathered from the terms of the relevant Act an intention to that effect. The Crown can be bound only by express words or necessary implication. The modern authorities do not, in my opinion, require that any gloss should be placed on that formulation of the principle. However, as the very nature of these appeals demonstrates, it's most desirable that Acts of Parliament should always state explicitly whether or not the Crown is intended to be bound by any, and if so, which of their provisions. So, Your Lordships and my Lady will note his reference to the simple, sticking to the simple rule, and not, and the fact that, the need not to put any gloss upon that formulation of the principle. Again, your Lordships and my Ladies saw that the relevant Act of Parliament, the relevant 1984 Scottish Act, created an offence in relation to placing an obstruction on the road, but neither the Solicitor General for Scotland, who argued the case, or the court suggested that the Crown's potential exposure to a penalty for non-compliance with a notice not to put an obstruction on the road was a reason for saying that the Crown should not be bound and was not bound by the Act.
There was something, wasn't there, fairly powerful in the positive indication the other way. If you look at 646D, making the point that quite a lot of roads in Scotland, and for that matter in England, are trunk roads which belong to which are controlled by the Secretary of State in any event.
That's right, and there's a hint. There's a hint of that in the. Was more than a hint of that. It's spelt out by, as my Lord points out, by Lord Keith in that paragraph. Well, again, with more than a reference back, we suggest to what your Lordships and my Lady have already seen in the earlier cases, to land controlled by the Crown that shouldn't be controlled by local authorities. Finally, can I take you to the Liverpool coroner case behind the next tab, tab 5, a decision of Lord Justice Gross and Mr. Justice Burnett, as he then was. And your Lordships will see from the opening words of the headnote that the coroner had issued notices under Schedule 5 to the Coroners and Justice Act 2009, requiring the Revenue and Customs Commissioners to provide certain information to him. The Commissioners sought a judicial review of the decision to issue those notices, and the question then arose as to whether the Crown was bound by the Act which gave power to the coroner to issue such notices. Can I go to the... I'm asked to read para 1 of the headnote. The coroner who was conducting an investigation... of the holding, held, dismissing the claim, 1, that the Crown was bound by necessary implication by a statute in which it was not expressly named, only if the statutory purpose would be wholly frustrated unless it were so bound, and it did not suffice to show merely that the legislation could not operate with reasonable efficiency or that the statute had been enacted for the public good. So the Divisional Court felt itself bound to apply the earlier reference in the Bombay case to of the Privy Council to the wholly frustrated test, and indeed did so.
They applied it and said that it was met.
Correct. And our primary submission on this appeal is that if one applies the wholly frustrated test to the facts of this case, likewise, the test is met.
But the whole statutory purpose is wholly frustrated.
Well, I'll come to my submissions on that.
That's the difficulty. What does it mean, wholly frustrated?
Well, I respectfully agree.
Does this judgment, I'm sorry, I ought to have read it already, but I haven't. Does this judgment simply extract the wholly frustrated, those two words, from Lord du Parc in Bombay, or does it examine what you say is a difference of emphasis between that judgment and some of the others?
Or the former.
Right.
And having looked at the cases, Lord Justice Gross, who gave the judgment of the court, at paragraph 46, that's page 495, internally, MS 666, and the MS number for the case is 652.
Yes, thank you, but
I'm
I
sorry,
had found it.
Just in time, I hope. So, paragraph 46, pulling the threads together in deciding whether a statute binds the Crown by necessary implication. One, the court's task is to ascertain the true intention of the legislature from the terms of the statute understood in context. If the legislative purpose thus ascertained would otherwise be frustrated, then the statute would bind the Crown by necessary implication. The mere fact that a statute would not operate reasonably efficiently unless the Crown was bound would not suffice, nor would it suffice that the statute was enacted for the public good, though the purpose of the statute would or may be a relevant factor in determining whether the Crown was bound, and then a reference to the 1998 Human Rights Act.
Now, does that justify the head note or not?
Well, that was the approach that the court decided to adopt. So perhaps I'd better read on to see how it decided the case. So 48, MS 666, all that said in our judgment, the intention of the legislature...
Sorry, you're reading from...
I'm sorry, paragraph 48, MS 666. All that said in our judgment, the intention of the legislature in enacting the 2009 Act, and specifically Schedule 5, was plain. As appears from the history, the Act was intended to strengthen the powers of coroners and thereby discharge the obligation under Article 2 of the Convention to conduct an effective investigation. I miss out the next sentence. We can discern no coherent, still less cogent reasons as Schedule 5 applying to the police. That's the schedule which gave the coroner power to issue these notices, the NHS and private prisons, but not binding the MOD, the commissioners or prisons in the public sector. Nothing whatever to suggest a legislative intention to draw so curious a distinction. It is thus our clear view that the legislative purpose of Schedule 5 would be frustrated if it was not binding on the Crown. So they conclude that Schedule 5 doesn't bind the Crown by necessary implication. Then over the page at letter B, we are concerned here typically with matters such as the investigation of deaths in state custody. It seems to us implausible that Parliament would have legislated with a purpose already outlined and left key Crown emanations to cooperate or not, depending on whether they regarded such cooperation as possible and politic. Indeed, to do so could create the greatest difficulty for the Crown body's concern. We can well understand the Privy Council's concern in the Bombay case to keep the Crown's subservience to the municipal corporation within the limits of sensible cooperation. In the light of Ms. White's submissions, we did pause to consider the ramifications of paragraph 3 of Schedule 5. And if you could just go back to the foot of page 658, internal 487. you will see set out over the page, paragraph 3, a senior coroner conducting an investigation, if authorised, may enter and search any land specified in the authorisation. So picking up where I left off, in paragraph 50 at page MS 667, but again, with respect, we were not persuaded. As we understand it, paragraph 3 is not yet enforced, though we see that fact as neither here nor there. Crucially, a coroner can only be authorised to enter and search any land if any of the conditions set out in paragraph 3.3 are satisfied. The nature of those conditions is such that we regard it as bordering on the fanciful to suppose they would ever apply to Crown premises. If they did, it could only be in the gravest circumstances. For example, concern that a search would be seriously prejudiced if immediate entry was not secured. And in the supplementary bundle I handed up a little time ago, your Lordships and my Lady will find the full terms of Schedule 5 behind tab 3. Which include, in paragraph 3, a notice must explain the possible consequences under paragraph 6 and 7 of Schedule 6 of not complying with the notice. And if you then read on, go to page 22 of the bundle, the number is in the bottom right-hand corner of each page, you will get to Schedule 6, and you will see page 23, just over halfway down, part 2, paragraph 6, a senior coroner, or as the case may be, the coroner for treasurer, may impose a fine not exceeding £1,000 on a person who fails without reasonable excuse to do anything required by a notice under paragraph 1 of Schedule 5. So, as in the other cases I referred to, a failure to comply with those notices carried with it exposure to a financial penalty.
That's the giving of information, isn't it? Paragraph 1 is giving information.
Yes, and that's because that was the request made by the notice in that particular case.
The court was influenced and set out quite extensively by the background to the 2009
It was.
Act.
And that's why I've taken my Lady and your Lordships to the background to the 2006 Act, because we submit that is crucial to the determination of the question of whether the Crown was bound by Part 1 of the Act. So can I turn, and I'm sorry I've taken some time taking your Lordships through my Lady through the statute and the cases.
Could I just ask Mr. Havers, where does the head no right to get wholly frustrated from?
Yeah.
Well,
not in paragraph 46.
Yes.
Not anywhere.
Your Lordships.
He gets frustrated quite a lot. but
frustrated.
Your Lordship, absolutely right. Absolutely right. So when it comes to the actual ratio of the decision, your Lordship's right. Only the word frustrated is used, not wholly frustrated.
Well, not only that, but the bit of Bombay which includes that expression is not among the bits cited, as far as I can see.
It is.
Well done, it is there, is it? Thank you very much. Yeah, got it, thank you.
They treat that as all part of a coherent test. The test has been reiterated.
Paragraph 49 as well, he expresses the view that the beneficent purpose of the Act would be wholly frustrating. Second sentence.
So with the background that I've shown the court and the statute, the terms of the statute and the cases that I've shown you, can I turn to our submissions on this part of the case? Firstly, the materials that we've shown you, the background materials, disclose, we submit, a serious and widespread problem with smoking in public places and workplaces, which was causing serious health-related problems to a large number of non-smokers, that's to say passive smoking. This was a problem acknowledged domestically and internationally, and attempts to address the problem other than by legislation had failed. And thus the time had come to introduce legislation banning smoking in such places so as to address the problem effectively and provide protection for non-smokers. There's no evidence to suggest that this was any less of a problem in Crown premises, in particular for present purposes, prisons. On the contrary, the evidence shows that around 80% of prisoners smoke. The references are paragraph 10 of the appellant's first witness statement, page 220 of the appendix, MS 345, and paragraph 9 of the prison governor's statement, Terry Williams, page 263 of the appendix, MS 388.
The figure appears in the PSI, doesn't it?
Well, it does, yes.
Yeah.
Further, according to the evidence of the appellant and his witnesses, smoking by prisoners on landings and in their rooms with the door open was being ignored by prison officers, some of whom themselves smoked in such places, in prisons. And the references are paragraphs 11 to 15 of the appellant's first witness statement, page 220 of the appendix, MS 345, the statement of Mr. Lee, page 226 of the appendix, MS 351, the statement of Dana Abdullah, appendix 240, MS 365, the statement of Mr. Nesbitt, appendix 242, MS 367, and the appellant's second witness statement, paragraphs 12 to 16, appendix 276, MS 401. There is no evidence to suggest, we submit, that voluntary compliance with non-smoking requests was any better in prisons than in other places, or in state prisons rather than in private prisons. And therefore there's no evidence to suggest that a ban on smoking was any less needed in Crown premises, in particular prisons, than elsewhere. Now, I appreciate that Mr. Justice Singh, in his judgment, and can I turn up volume 1 of the authorities and go to MS 688 behind tab 5, no, tab 6, MS 670, at paragraph 94, he noted that no application had been made in the proceedings for cross-examination only of the witnesses, in particular Ms. Williams. In accordance with normal practice in judicial review proceedings, in my judgment, the court has to proceed on the basis that the written evidence filed on behalf of the defendant must be accepted insofar as there are disputed questions of fact. But if one looks above to the bottom of paragraph 92, and this is MS 688, I'm sorry, I may have missed the reference, we see that the governor acknowledged that it's possible that some prisoners might smoke in communal areas and not be observed by staff, and it's unlikely that many prisoners will complain about it. So,
Can I just invite the court to read from MS 687 at the letter G, where the assertion that is being put forward is recorded, but then the judge's judgment at 91, and then the rest of 92 and 3 before you get to 94.
my lady, there it is, as is so often the case in judicial review proceedings. One has conflicting evidence. One sees how Mr. Justice Singh approached that conflict, but the fact remains that there is evidence before your lordships and my lady from the appellant and his witnesses in relation to smoking in the common parts of the prisons.
How can disputed evidence about what's actually happening in prisons help on the question of necessary implication?
Well, it's simply part of the background context that I put before the court.
I see.
I come back to it again in terms of whether the purpose of the Act would be frustrated when I get to show the court, if time permits, some material which indicates that smoking in common parts is still widespread in prisons. And I will explain how I seek to put that material before your lordships and my lady when I get there. But I simply make the point that
We surely have to approach it with the frame of mind of the legislator at the time.
yes,
And
I simply
I suppose there are two possibilities. If the prisons weren't covered, the legislator might have thought, well, the government's going to tag on and in practice enforce a reasonable system. The legislator is certainly not going to assume that the system is going to be incapable of operating, is it? The alternative is your construction that the legislature must have intended this to be comprehensive.
yes.
I mean, the reality is, Mr. Havers, that the enforcement of regulations of every kind in prisons is fraught with enormous difficulties. Look at the statistics for the presence of mobile phones and drugs.
No, I appreciate that.
Some of the smoking, in fact, of that sort.
Yes.
How well it's going to be enforced seems, unless I've got it wrong, is really quite a different question from whether the necessary implication is there that it ought to be the legislative rule.
Yes, I put that material, that evidence, before your lordships and my lady, solely in the context of there being no evidence to suggest that passive smoking was any less of a problem in prisons.
Okay.
So that's the background that I rely on, the context for the Act. Then I come to the terms of the statute understood in that context. Now, firstly, the scheme of the Act, which, as I've already submitted, is as follows, namely, Section 2 provides for the general prohibition on smoking, subject only to certain specific and very limited exemptions which Parliament intended should be approved by Parliament by way of affirmative resolution. And I don't think that I showed the court Section 79(4) as I had intended. It's in Volume 2 of the authorities' bundles, behind tab 13.
Yes.
And the MS number is 876. And you will see that section 79(4) provides that no statutory instrument containing regulations under section 3, that's the exemptions section, 4, that provides that the national authority may designate additional smoke-free places. Section 5, that's designating vehicles. Section 6(8).
Sorry, which page are you reading from?
So sorry, MS 876.
Section 79.
79(4).
Yeah, thank you.
So I'm just looking at the regulations covered by paragraph 4. 6(8), which are the regulations for setting the level of the fine. 7(6), the same. 8(7), the same. And if we go to the to below little f, may be made by the Secretary of State unless a draft of the instrument has been laid before and approved by resolution of each House of Parliament. So the affirmative resolution procedure applies to regulations made under those sections of the Act. And so that's why we submit that the scheme is that Section 2 provides for the general prohibition on smoking, subject only to certain specific and very limited exceptions, which Parliament has first to have approved under the affirmative resolution procedure. Secondly, as to prisons, the fact that Parliament expressly referred in Section 3, subsection 2, to the possibility of an exemption being made in respect of prisons is a statutory indicator, as Mr. Justice Singh put it, that Parliament envisaged that unless an exemption applied, prisons would be covered by the Act. There's no indication in the Act that Parliament intended the reference in the Act to prisons to be confined to what were then the only 10 private prisons in existence, or to draw any distinction between private prisons and state prisons in this context. Thirdly, that Regulation 5(2)(c) of the 2007 regulations, which you will recall makes an exemption for designated rooms in prisons, likewise draws no distinction between private prisons and state prisons, thereby confirming the interpretation I have just set out. And of course, it makes no further exemption itself for or in respect of prisons. The ban is backed up by enforcement provisions and by the creation of certain offences, so as to ensure that the ban is effective. So we submit that, set in its context and looking at the terms of the statute, Part 1, the terms of Part 1 indicate that Parliament intended the ban to apply to all public and workplaces, subject only to those exemptions, in order to protect those who work in or visit those premises from the health risks of passive smoking. And that effectively summarises the purpose of the Act, to provide effective protection for all those people, subject only to those specific exemptions. Parliament did not intend, we submit, that there should be a very wide range of further exemptions, namely all Crown premises, nor did it intend that those who work in or visit those premises should not be protected from passive smoking. Which takes me then to the question whether the purpose of the Act would be frustrated if the Crown, the purpose of Part 1 would be frustrated if the Crown wasn't bound by it. We submit that it would. First, at a stroke, a very large number of public places and workplaces would be excluded from the ban. A ban which the government and Parliament had decided was necessary to protect non-smokers from passive smoking. And we set out, or we include in the appendix at page 430, MS 555, time doesn't, I think, permit me to take you to it, a list of Crown premises, which we invite you to look at. As a result, there will be some curious consequences in terms of where the Act will apply and where the Act won't apply, which we set out in paragraph 53 of our case, MS 61. And again, I don't take you to them, but they include, for example, smoking being allowed in the Royal Courts of Justice, but not in the public house next door. Specifically in relation to prisons, 90% of the prison estate in England will be excluded because state prisons comprise 90% of the prisons in England. And thus all those who work in and visit those prisons, and indeed who live in them, in the sense that prisoners live in their cells when detained, will be excluded from the protection against passive smoking. So, in other words, the vast majority of prisoners won't be protected, and the vast majority of prison officers likewise, and visitors as well. Instead, they will have to fall back on
yes, I mean,
review.
don't overstate visitors, Mr. Havers. Visitors are in specific places in prisons, aren't they? They don't wander around the cell blocks.
Sorry, Mark.
Don't overstate visitors. Visitors are in specific places in prisons.
Yes.
They don't wander around the cell blocks.
Depends on the visitors,
It depends on the visitor.
Oh, I see what you mean. Yes, okay.
not just people visiting prisoners.
No, okay.
Occasionally, judges wander
Yes.
around all sorts of parts
Yes.
of the prison.
Wide range of people, yes.
Yes, point taken.
So as I was saying, instead, all those people will have to fall back on judicial review as their only remedy. So let me compare the two in terms of effectiveness and availability. Firstly, under the Act, all that is required is a simple telephone call to the local authority, which then takes on responsibility for enforcing the ban, pursuant to, your Lordships and my Lady will remember, the statutory duty that it is under to do so. So a simple, immediate, either cost-free or low-cost telephone call will be all that will suffice. And indeed that is set out in another NHS smoke-free document at page 285 of the appendix, MS 410. Again, time doesn't permit me to take you to it. Whereas, I come to judicial review, if judicial review is the only option, and the respondent, I think, accepts this, first question, could the complainant afford it? Secondly, even if he or she could, the process will take months, if not years, to be concluded. Thirdly, it will be the opposite of a simple procedure. It will almost certainly need lawyers to draft the papers and represent the complainant. Fourth, what would the judicial review be of? Very difficult to imagine how a judicial review could be created so as to provide any sort of protection for those who visit prisons or work or live in them.
It would be on a health and safety basis, so it would be Article 2 or 8 of the Convention.
Well, I suppose that's one option, but
Yes, of what?
the court would then have to consider whether the decision of the Secretary of State, assuming that was the person proceeded against, was justified under Article 8.2.
Well, it would have to be a judicial review, I suppose, alleging failure to protect the necessary interest.
I suppose that would have to be the general nature of it.
Because it wouldn't be a decision.
Sorry, Mark.
Wouldn't be a decision.
No. But then, of course, we know what the court's powers are on judicial review, essentially supervisory. So whereas the local authority is under a duty to enforce the ban under the Act, the court, on any sort of judicial review, would be able, we suggest, probably to do very little to assist the complainant at the end of the day, or at least may well be restricted in what it could do to do so. So we submit the judicial review is a very poor substitute for the powers of enforcement created by the Act. And we submit it's difficult to believe that Parliament intended that this should be the remedy available to all those who will not be protected by the ban if Crown immunity applies. On the contrary, we say there's every reason to think that judicial review would be far less effective than the statutory ban, and that this has turned out to be the case, thus confirming the proposition that judicial review will be far less effective. But I see the time, and since I'm about to take you briefly to one or two further documents in the appendix,
Well, that sounds like a convenient
it
moment.
may be a convenient moment.
We look forward to hearing from you further at 2:00. Court is now adjourned.